So good evening, everybody, and thank you so much for coming out in such great numbers tonight. I am going to speak actually quite specifically about the Crotty decision. So this decision is very familiar to you and celebrating its 25th anniversary this year with more or less numbers of parties across all of the member states of the EU, depending on how they view the impact of this important decision. I came to understand really well how important this decision is across Europe when I first went to the EUI in 2003, and there I met somebody. We were introducing ourselves. I met somebody and they said, "Hello, what's your name?" And I said, "Maria," and they said, "Where are you from?" And I said, "Ireland," and they said, the Crotty decision. And this was the one reference point they had, not Shamrocks or St. Patrick's Day or anything like this, but the Crotty decision. Tonight, just to kind of go through it and to look more carefully at what is involved in the decision and maybe some criticisms we might have, and to reawaken our sensitivity to what's really going on there, because there are some implications that will be played out in the next years potentially that we need to be ready for. So, a few things about the case itself. Obviously, the first thing is it's kind of a dramatic case. So you have this one guy going to the house of a High Court judge on Christmas Eve and the day before Christmas Eve asking for an interlocutory injunction to prevent the ratification going ahead of the Single European Act. It's also got this heroic quality to it, which the students always pick up on. So last year it was on the exam. I teach constitutional law now, not replacing Professor Morgan, but in the place where he used to teach it. And there the students were asked to discuss the Crotty decision, and so there were two that stood out for me. One was a very good exposition of what was involved in the case, and then at the end the line was, "Thank you, Mr. Crotty, for defending our country." And then the second one developed this very good analogy between, at least it was well argued, between Crotty and Spartacus. So again, showing that this is how they understood that he had acted. So this heroic quality of the judgment appeals, at least to them. On the other side, it's incredibly technical. So there are so many procedural things going on there to do with locus standi, to do with the nature of the remedy, to do with the division between those parts that had already been signed into law by the President in the Act, so Title II, and those parts which had not yet been properly ratified at parliamentary level, so there were Title III. And so you have then 6 judgments by 5 judges and lots of different factors at play in those judgments. And then obviously also we know it's subject to huge amounts of criticism. And as far as I can gather, a lot of the criticism there is actually directed towards the nature of the outcome. So people are unhappy with the fact that the effect of the Crotty decision is that people have to vote on things that they don't know so much about. So this came really to the fore at the end of the first Lisbon decision, the first Lisbon vote, where there it was the 53 on 53 argument. So 53% of turnout of 53% of people voted no in one of the smallest countries in the EU, and that ground to a halt this long-awaited, very overdue ratification of a treaty which had an effect on 500 million people. So it seemed that there is a disproportionate influence that the effect of the Crotty decision has on the possibilities of ratifying European treaties. So that argument was actually made on democratic grounds. People were saying in the Italian newspapers in particular that this was an undemocratic effect of the Crotty decision, that so few people were holding up the process for so many. And that, of course, you have to ask them what they mean by democracy, ask them whether they think Europe has one demos, and all of these questions, and at some point they back down very sheepishly. But there is something in there. There is something in the idea that it might be unreasonable to expect people to be able to muster the enthusiasm, to read these documents that are 300 pages long, to know what's involved, to develop some sort of judgment based on the information they have. The one statistic that was always quoted when we realised, or when we learnt the results of the Millward-Brown investigation into what had happened during the first Lisbon decision, was that 55% of those who voted no admitted that they didn't understand what they were voting on. And the answer to that is Gráinne de Burke admitted that she didn't understand fully what was involved in the treaty either, and if she can admit it, we can all be quite comfortable in admitting too that we have difficulties understanding these things. But the one that people didn't advert to, or didn't want to advert to, was that 80% of the people who voted yes on reasons that had nothing to do with the treaty. So still, that's not giving you a good kind of basis, but I think the argument is worth engaging, even just as a theoretical argument. Is it not ridiculous to expect people to be able to engage in these treaty ratifications, to be able to make a judgment on them, and therefore to promote or to hold up the process of European integration? Except that that's not what we're doing. So this, yes, is the effect, but actually we don't vote on European treaties because we're interested in the treaties. It's not a consultative referendum to understand how the people stand on the issue. It is instead a referendum that's really embedded in our constitutional infrastructure. So it's a referendum not because we want to proclaim ourselves to be experts on European law, or the effects of European integration, or the political dynamics that are at play, or whatever, but because this referendum, this treaty, will involve an amendment of the Constitution implicitly, and when we have an amendment of the Constitution in Ireland, we have to do that by referendum. So it's not a standalone thing outside of the normal constitutional infrastructure, where Irish people are particularly interested in voting, or particularly insistent on having a say, but rather that we have the peculiarity, as Judge Hogan was discussing earlier, that when we have an amendment, it must be done by referendum. So the reason that the people are involved is Article 46, not anything else. It's just simply due to Article 46. So with those kind of opening comments, the plan now, in the short time that we have remaining, and I'll try to cut it down because we're already over time a little bit, is to discuss the test in Crotty. So I want to look at the test itself, which probably you don't need reminding of, and then 2 rationales and 3 criticisms. And we'll stop at the end of those criticisms. So the test, you will know, was laid down by Mr. Justice Finlay, and he started with the Article 29.4.3, which was the article that allowed Ireland to become a member of the European Economic Community, as it was at the time, in 1973. And he ruled that the provision must be construed, and now I'm quoting, as an authorization given to the state not only to join the communities as they stood in 1973, but also to join in amendments of the treaty so long as such amendments do not alter the essential scope or objectives of the communities. So that's the part that everybody knows, essential scope and objectives. He says if you make it anything less than that, it's too narrow, and if you make it anything broader than that, it's too broad. So it must be on this essential scope and objectives test. When he reformulates it, because he does it 3 times, when he reformulates it, it becomes the essential nature and scope of the objectives of the communities as they must be deemed to have been envisaged by the people in enacting this Article 29.4.3. So there we have a qualification or a slant that's being put on the essential scope and objectives test that it is the essential scope and objectives in the mind of the people as they voted in 1973. Now, unfortunately, we don't have kind of unanimity on what the rationale for the decision is, because of the fact that the test is laid down in the one single judgment of the court on the question of Title II, and then afterwards, when the different judges are giving their 5 judgments on Title III, you understand what they themselves individually intended by the test that was laid down originally. So I'm piecing together from now the majority judgments, so the 3 majority judgments of Hederman, Henshey and Walsh, and from them I think it's fair to deduce 2 threads that give us an understanding of what the rationale is, or the co-rationales behind this test. So the first one will be the one that focuses on the limited nature of the authority given to the executive power. So that thread is definitely running through the judgment, where Walsh in particular and Hederman, want to emphasise the fact that the government has powers. Sure, it operates on the external level, it can do many things, but none of those things are without limit. And those limits are preserved in the Constitution, and those limits must be honoured. So that just delimitation of the executive power in external relations is one of the rationales for the test. That they are not unlimited, that, as Walsh says, they are the creatures of the Constitution, and so they must respect the fact that they are creatures and not creators, and they must not act free of the restraints that have been imposed on them. Hederman makes the point very succinctly in his tiny judgment at the end, but his analogy kind of is that they are guardians of the powers that belong to the people. And then the other way that I use sometimes is that we can understand the executive powers to be trustees for the beneficiaries who are the people. And so the trustees then cannot dispose of the powers, Professor Mee assures me at least that they cannot, without the beneficiary having decided so. So that one rationale is definitely running through the majority judgments. The second rationale, which is entirely complementary, is that the people are ultimately the guardians of these powers. So here you find many references to the power of the people or the position of the people. Lots and lots of references as well to Article 6 of the Constitution, which says that the people shall be the ones to decide in final appeal all questions of national policy according to the requirements of the common good. Okay, so that thread, as I say, is entirely complementary to the first one, and it's based primarily in the judgment on Article 6. It's not really well buttressed in terms of principles, so you can imagine there that one could develop a whole understanding of democracy arriving out of Article 5, or representation, or the importance of recognising the importance of the constituent power, but that's it's not developed any further than that. It's there just as a reference to Article 6 and the final appeal to the people. Okay, I'm skipping a small bit, and we'll actually just jump straight into the criticisms now. So these criticisms I have are not obviously criticisms to do with the outcome of Crotty. I'm not going to be saying the people aren't intelligent enough to be making these decisions. I'm also not going to be saying that there shouldn't be a test. I do think that while the test in Crotty isn't perfect, the idea that there should be a test is valid. I think that is convincing. My first point of criticism would be to do with the lack of reference to Article 46. So I would have thought that the judgments would have relied more on the amendability clause itself. So Article 46 and 47 that we've heard exposed really well this evening hardly get a mention in the judgment, even though they are the basis presumably on which the judgment ultimately rests. So if I had been a judge, and I wasn't because I was too busy being a little girl in first class at the time, but if I had been a judge during this judgment, I would have said the Single European Act causes an amendment in our Constitution. We cannot have an amendment in our Constitution until it's ratified by the people according to Article 46. End of story, that's it. If you want to change the Constitution, it has to be done in the way that we've outlined in Article 46. So that kind of really simple, basic point is lost, I think, or is not grasped as it could have been as a really strong buttress for the decision, or pillar for the decision. Because that's our deal. So that's our fundamental deal with ourselves, that if we're going to change the Constitution, this is how it's done. It's the bottom commitment, the basic commitment that we have, or our basic deal. And as Judge Hogan said, there are good reasons behind that, and we can't kind of overlook the fact that this is the way that it works. That approach is the approach that, for example, is taken by the French Conseil Constitutionnel in the Maastricht 1 and 2 and 3 decisions, in the Constitutional Treaty decision, and in the Lisbon decision. So they have just said, if it requires an amendment to the Constitution, then the amendment has to go ahead. There it's slightly different because the President of the Republic can choose in his discretion whether or not to send it to the people for a referendum. So for the Constitutional Treaty there was a referendum, and there the people voted against, and then Sarkozy decided he wasn't going to submit it to the people when it came to the Lisbon decision, and so that's why that got through very safely. So that's my first criticism, the lack of reference to Article 46. The second one focuses on essential scope and objectives. So here, as I kind of flagged earlier, it is the essential scope and objectives in the mind of the people when they were voting on membership in 1972, and so then when we arrived to membership in 1973. And I think there are three things to remark on about this test. The first one is it's promoting original understanding as a method of constitutional interpretation. So there, the proposal is that we look into the mind of the people, the original understanding that the people had in 1972 when they were voting, and not only the original understanding of the drafters, which is always problematic to try to look at, but the original understanding of the people on something that's actually quite technical and complex and difficult to understand. So this is not entirely in sync with what the Supreme Court usually does. So original understanding isn't generally the preferred method of constitutional interpretation, and it's slightly anomalous then that it should be used in this one case where it seems even more difficult than usual to know what that original understanding might mean. Secondly, then, still dealing with this essential scope and objectives test, secondly, there's an odd feature about it in that it's looking at diachronic change, so change across time, from the original endorsement, if you like, at the moment of membership to the next treaty, and presumably every time after that as well. So you just, as you're applying the test, it's like you have to look back, freeze the moment the people last knew what they wanted, try to understand what was in their heads then, and see how much has changed since. So it's a new original understanding that's happening every time, and a new procedure. So the test almost shifts itself because it becomes transported through time as the people get to vote on more and more. And this is just convoluted. Again, it would be easier to say we check whether there is an amendment that is causing a change in our constitution, or we check whether the new treaty that comes before us is causing a change in the constitution. If it does, it goes to the people, and if not, it doesn't. So that would be a more straightforward way, I think, of working it, rather than trying to understand these diachronic changes. And thirdly, we don't normally set a threshold test for the importance of what we're doing when we are making an amendment. So, as we heard earlier again, the transitory provisions did allow for changes in technical matters, but after that, it's now the case that Article 46 requires an amendment for any change in the Constitution. So it doesn't have to be a big thing, it could be a really small thing, but still, if there's an amendment of the Constitution, it must be done by this referendum. So we don't have amendments only for essential changes in fundamental rights provisions or essential changes in separation of powers balances. And here again, the Crotty decision is anomalous in that it's saying there will be an amendment if it's an essential change, but not if it's a non-essential change, and someone has to determine whether or not the change is an essential change. Okay, it's been suggested, and I think this is probably true, that the reason that you have that essential scope and objectives test, or the essential part of it at least, is that there was some kind of desire on the part of the court to separate Title II and Title III. So Title II had already gone through, in a sense, and had been signed off by the President, and the President hadn't referred it to the court to check, and so there would have been kind of political embarrassment there. And rather than doing that, they wanted just to sign off on Title II, allow it, to go through, whereas they wanted to say there's something different happening with Title III in the foreign policy section. So I'm conscious that I'm not going into any of the detail of the Single European Act, but probably you'll thank me for that, because it's so late in the evening and there's so much to do when you do start to dig there. The final thing I want to say then, the final criticism, and this one points towards the future, is that in that decision there was no consciousness whatsoever that at some point we might want to put a brake on all of this. So there's no kind of sense that at some point there should be a limit on our capacity to incorporate treaties that cause such a great transfer of competences from national to supranational institutions. I don't think that they are great models, but in Germany, for example, there are limits at least written in the Constitution. The Bundesverfassungsgericht has a strange way of protecting them or honouring them, but they are there, that there can be no change to democracy and no change to the protection of dignity, no change to the federal structure. So those limits exist so that the Constitution cannot be changed in a way that affects any of those provisions. In Spain, they have a very complicated way of making an amendment whenever sovereignty, language, the position of the political parties, fundamental rights provisions and so on are affected, and so that itself is a limit on what can be done there. And as I say, I don't think those countries manage to defend those limits in the way that they should. The constitutional courts there sort of wander around protecting those limits and then use them in different ways, which I'm developing a theory about. But I do think it's a question we need to ask ourselves. Is there going to be, or has there already been, a moment past which we cannot say anymore that we're just amending our Constitution, and in fact we've undermined it so much that it's not worth talking about anymore? So that's all I have to say. Thank you very much.